Good morning, everyone. My name is Julia Casa and I am the NECA Membership Manager. I welcome you all to the NECA webinar on changes to closing loophole bills. Today we are joined by Lisa Carey, NECA's Senior Legal Associate, who will guide us through the latest changes in the workplace relations landscape. If we could please hold all questions until the end of the presentation, where Lisa will address your questions or concerns that you may have. So let's get started.
Sorry. Okay, so good morning, everybody. Hope you've had a lovely day so far and that you're fully rested. It's well, it's going to be a bit of a dry presentation today, but a necessary one, unfortunately. Employment law has changed a lot over the last year or two, as you've probably noticed, and there's so much going on. It's really, really hard to keep up with all the different changes in the laws and requirements. And I don't know if it's the same for you. Every time I turn around, there's a new piece of legislation that's or a clause or a provision or a requirement that's come into play. So I'm going to try and help you understand all of that today. And you may have spoken with me over the phone, but I am the senior associate in the legal team and I run the employment law practice. And I started with NECA in October last year. And yeah, I've just sort of been getting used to the electrical contracting space, which has been a lovely experience so far. And nice to meet a lot of you guys. Now, I'd just like to say that this presentation has been funded by the Australian Chamber of Commerce and Industry, or ACT. We do a lot of work with ACT and they advocate for small businesses and businesses throughout Australia. And we work with them in advocating for our members in the electrical contracting industry. So we're grateful for ACT to be able to provide this training to our members. So there's a lot to cover today and I will move through it quickly, but keep in mind you can reach out to myself or the team at any time if you require clarification or assistance with anything discussed today, and we can help you with your specific questions or your scenarios for your particular business. I will give a brief overview of the Closing Loopholes Bill, followed by a summary of the changes resulting from the bill. And I will let you know what NECA is doing to advocate for its members in this area. So first, an overview of the Closing Loopholes Bill. As many of you know, the Fair Work Legislation Amendment Closing Loopholes Bill 2023 was introduced to Parliament on 4th of September last year. It brought with it 278 additional pages to the Fair Work Act. And the Fair Work Act already had 1,200 pages, so it's quite a significant piece of legislation now. Just to give you a bit of an idea, 2 years ago, it was about 700 pages. So there is a lot going on there. We have been consulting with the Fair Work Commission on a lot of the changes, and we did go to the parliamentary inquiry in, I think it was November last year, where we advised the Parliament of the impacts it would have on our members, after which time the bill was deemed too large and controversial in parts, so it was split into two tranches. The first tranche was the Closing Loopholes Bill number 1, which contained less controversial provisions and was passed into law on 14th of December last year, and the Closing Loopholes Bill number 2, which was passed by Parliament on 12th of February this year, with a sneaky little addition in the form of a right to disconnect. So I'll start with Closing Loopholes Bill number 1. Now on the screen there's a little timeline of some of the changes we've seen and some of the changes still yet to come. The majority of these changes came into effect on the 15th of December 2023, followed by other changes that will occur throughout this year and next year. Some of those changes include workplace delegate rights, family and domestic violence protections, small business redundancy, exemption, union right of entry to assist workplace health and safety representatives, labour hire orders, protected action ballot, workers' compensation claims for first responders experiencing PTSD. On the 1st of July 2024, so a couple of weeks ago, the criminalisation of industrial manslaughter came into effect. On 1st of November 2024, same job, same pay will come into effect for businesses with more than 15 employees, and a year later for businesses with less than 15 employees. And no earlier than January 1 next year, the criminalisation of wage theft will come into play. So workplace delegates' rights, we'll start there. They've expanded, whereby a workplace delegate appointed or elected by a union to represent its members now has the right to represent union members in industrial disputes, reasonable communication with members about industrial matters, and has reasonable access to workplace facilities. Delegates employed by non-small businesses are further entitled to reasonable paid time during regular working hours for training. The changes also introduce general protections and potential penalties prohibiting employers from unreasonably refusing to engage with delegates, knowingly providing false information to them, or obstructing the exercise of their rights. From July 1 this year, all awards and enterprise agreements voted on after that date must contain a term providing for the exercise of rights of workplace delegates. NECA consulted with the Fair Work Commission regarding the wording of this model term, which is now in effect. And to ensure you comply with this change, you should be aware of who is a workplace delegate at any given time in your organisation, and make sure that you're complying with the model term. This term will need to be added into any enterprise agreement as mentioned, and we're starting to do that for people where we're doing their enterprise agreements for them. It's quite a long term, so I haven't put it there, but if you want us to send you a copy of it, let us know. So there are also now stronger protections against discrimination for employees facing family and domestic violence. Similar to sex, gender, pregnancy, race, etc., family domestic violence is now a protected attribute under the Fair Work Act, and employers are unable to discriminate or take adverse action such as dismissal based on an employee's current or past experience with family and domestic violence. This protection extends to potential future employees also. Further, awards and enterprise agreements must not contain terms that discriminate against employees due to their experience with family and domestic violence. Not that I think any of your agreements would do that, but it's good to know. What you can do is to create or review any policies regarding discrimination and include this new attribute. You should then provide a version of the policy to staff and train if necessary, making sure you identify the new requirement. Redundancy exemptions. So on the 15th of December 2023, changes were introduced regarding redundancy pay for employees in the context of downsizing. Typically, small business employers are exempt from paying redundancy to redundant employees where the business has fewer than 15 employees. However, if a non-small business becomes a small business due to insolvency, such as bankruptcy or liquidation, the employer was previously exempt from paying redundancy to employees. The recent laws mean that non-small business employers that become small businesses in the circumstances may still be obliged to pay redundancy to affected employees where they are made redundant within 6 months of the bankruptcy or liquidation. The impact of this on business is that they must factor in redundancy costs for all employees if a business becomes a small business due to insolvency. And what to do is just make sure you pay the employees the redundancy in these circumstances. So a good example of this is where you make your company redundant. You do it in different stages, and generally the people who are last standing are maybe finance and HR. And once the business gets down to under 15, those people are actually, or under the previous laws, they're actually not entitled to redundancy pay, which obviously is not as the laws were intended. So right of entry to assist workplace health and safety representatives. The laws are now such that from 15th of December last year, union officials can enter a premises to assist a health and safety representative without requiring a union right of entry permit. This means that there are no checks and balances on who can enter a work site without a permit. Consequently, businesses have limited recourse to influence their behaviour while on site. The amendments include requirements for officials entering premises in these circumstances to comply with reasonable directions from employers relating to workplace health and safety, not intentionally hindering or obstructing any person or otherwise act in an improper manner, not misrepresent rights that the official may exercise as a health and safety representative's assistant, and not use or disclose information or documents obtained as a health and safety representative's assistant for an unauthorised purpose. Further, in these circumstances, the amendments will impose requirements on other persons, such as employers and occupiers, to not refuse or unduly delay entry onto premises by an official, and to not intentionally hinder or obstruct an official who is assisting a health and safety rep. So what to do here? You, again, need to update your policies and procedures around right of entry and train staff on the changes. Stay up to date with the right of entry requirements and enforce them where legal and necessary. So new rules for labour hire workers. These were introduced on the 15th of December 2023 also with regard to same job, same pay. The changes allow employees, unions and host employers to apply to the Commission for an order that labour hire employees must be paid at least what they would receive under a host enterprise agreement. The Commission can only make an order if it's satisfied that the host enterprise agreement would apply to the labour hire worker if they were directly employed and where a valid exception does not apply. A valid exception may include where it is not fair and reasonable in all of the circumstances to do so. The Commission will have regard to submissions in this respect. For example, whether the host employment instrument is of limited application, the history of industrial arrangements between the employer and regulated host, whether they are related bodies, corporate or a common enterprise. Also, where the arrangement is for a service rather than the supply of labour to a host employer, the Commission will consider the extent to which the employer directs, supervises or controls the employees when they perform the work, including by managing rosters, assigns tasks or reviews the quality of the work, the extent to which the employees use the employer's systems, plant or structures to perform the work, and the extent to which the work is of a specialist or expert nature. Another exemption is where staff are engaged by the direct employer as trainees under state or territory training arrangements, so things like apprentices. Short-term employment arrangements are usually exempt. These are usually of a duration of 3 months or less, so as not to impact labour hire for surge work or where short-term replacement workers are needed. Labour hire employees covered by an order of the Commission will be entitled to be paid at least what they would receive under the host enterprise agreement or equivalent public sector determination. These changes do not impact the wages of host employees or labour hire employees. The Commission's orders allow employees, unions and host employers to seek new types of orders related to labour hire employees. These orders mandate that employers must pay their employees that are working for host employers at least the same rate as specified in the host employers enterprise agreement equivalent employment instrument. So disputes can be escalated to the Commission and penalties apply for non-compliance, including prohibitions on arrangements hindering or avoiding the Commission's orders. So these orders can be obtained prior to 1st of November. 1st of November, I think they come into play. But yeah, they're not actually effective until 1st of November. So it's just, that from the 15th of December, you're actually able to get those orders. So if you do have an order coming up after 1st of November, you will need to comply. Protected No, sorry. So sorry, yeah, what to do? Start reviewing your need for labour hire going forward. You may like to consider utilising fixed term contracts if your enterprise agreement allows it for periods of greater than 3 months. Keep track of any same labour hire orders that are made by the Commission between now and 1st of November, and start thinking about amending contracts with labour hire companies to ensure that they are paying their staff at your enterprise agreement rates if there is not an order in place, and that's what you wish to do. So moving on to protected action ballots. A protected action ballot is a secret vote by eligible employees on whether or not they want to take industrial action for a proposed enterprise agreement. This usually happens when negotiations are not going great and they want to be able to participate in industrial action, I guess, to move the bargaining process along. They can only do that if a protected action ballot is approved by the majority of eligible employees. Where the Fair Work Commission has made a protected action ballot order in relation to a proposed enterprise agreement, they are required to make an order directing all bargaining representatives for the proposed agreement to attend a mediation or conciliation conference, which they generally want to hold at short notice, like within 2 hours sometimes. The impacts for industrial action is for industrial action to be protected, the employee bargaining rep who applied for the protected action ballot order, it's generally the union rep, and the employer must attend the mediation or conciliation conference. Now, what to do is try and attempt to resolve issues if you can during the bargaining process. If that is not possible and you're at an impasse, then make yourself available for the mediation or the conference. In my experience, it's very hard. Well, Fair Work Commission generally will approve a protected action ballot order unless you can prove that the union or the employees are not bargaining in good faith, or they're not genuinely bargaining. So if you need any advice on that, give us a call, because there's a lot of rules and requirements around what that actually means. There were other reforms that came in on the 15th of December, including streamlining the Comcare workers' compensation claims process for certain first responders who sustain post-traumatic stress disorder, which shouldn't impact this group too much. And the functions of the Asbestos Safety and Eradication Agency was expanded to include silica. I won't go into further details on these because they are quite specific, but if you do need more information, obviously just let us know. So industrial manslaughter. Penalties, including incarceration in relation to industrial manslaughter, are currently, were currently dealt with at the state or territory level in either the relevant workplace health and safety legislation or the criminal code. From 1 July 2024, the Commonwealth Work Health and Safety Act 2011 was amended to introduce a new criminal offence for industrial manslaughter and significantly increased the penalties for other offences. An industrial manslaughter offence for the Commonwealth Work Health and Safety jurisdiction provides for penalties of $18 million for a body corporate and 20 years imprisonment for an individual. If you are a state or territory that already has this criminalised, not a lot will change for you, but for those of you who don't, this law will impact officers. So I think New South Wales, it's currently under the criminal code, and ACT, I'm not actually sure, but yeah, regardless, it's now in effect under that national legislation anyway. So under the Work Health and Safety Act, an officer is a person who makes or participates in making decisions that affect the whole or a substantial part of the business or undertaking. So if you are an officer, you need to keep this in mind, that, yeah, you are potentially liable if something goes wrong and you've contributed to that. There will be significant increases to the Category 1 offence penalties also, and these will be from $15 million for a body corporate, $3 million for a person conducting a business or undertaking or an officer, and 1.5 million and or 15 years imprisonment for an individual who commits an offence. So what I would be recommending that organisations do is conduct an audit of your WH&S policies, procedures and SHWMs to ensure they are sufficient, provide training to staff and officers on WHS policies and procedures, and I would also ensure that all officers within the organisation review their WHS policies and procedures in their area to make sure they are comfortable with what is in place. Ignorance is generally not a good defence. Same job, same pay. Although labour hire orders can be made by the Fair Work Commission from 15th of December 2023, as mentioned, they don't come into effect until 1st of November 2024. If there isn't a labour hire order in place, it is the obligation of the host employer to provide the labour hire employees with a copy of the new agreement. Host employers, under certain circumstances, are obligated to notify and apply for variations with the Commission. Exceptions to these orders include situations deemed unfair, services other than labour supply, such as specialist contractors, and cases involving small business employers, as I mentioned before. And disputes, like I said, can be escalated to the Commission. Penalties for non-compliance apply, including prohibitions on arrangements hindering or avoiding the Commission's orders. So if the Commission makes an order, you need to comply. All right, so that was a Closing Loopholes Bill number 1. So let's move on to Closing Loopholes Bill number 2. The changes under the Closing Loopholes Bill number 2, as you can see here, again, they sort of span throughout this year, and a lot of them have already come into play. The right of entry should be before the 26th of August there, but anyway, I will change that. The changes in the Closing Loopholes Bill number 2 include changes to enterprise bargaining, changes to amalgamation rules, changes to sham contracting defence, and increased penalties for breaches of certain workplace laws that came into effect on the 27th of, or that come into effect on the 27th of February 2024. So on 26th of August, there are a lot of changes coming in. So there's a new definition of casual employee. There are changes to the casual conversion process. There are changes to the employee and contractor test. There is a new definition of employer and employee. There is also changes to the employee versus contractor test. There'll be the right to disconnect. There'll be increased penalties for breaches of workplace law, changes to how unfair contract terms can be disputed. There was a new union right of entry to investigate underpayments, and on 1st of July, there were changes to the right of entry for suspected underpayments as well. There's also protections for gig workers and road transport workers, which I'm not going to go into today as it's not really relevant to this audience, unless someone has started an Uber type electrical business, which I'm not sure if that's even possible, but if there is for some reason you've got some gig workers in your organisation, give us a call and let us know if you have any questions on that. Okay, so enterprise bargaining changes. There are some changes in this area from 27th of February 2024. Multiple employers who are franchisees of the same franchisor or related bodies corporate of the same franchisor can access the single enterprise stream in the enterprise bargaining framework if they want to. There will be new rules allowing the transition from a single interest employer agreement or supported bargaining agreement to a single enterprise agreement. Changes to intractable bargaining determination provisions, which is an intractable bargaining determination is when the Commission decides on the terms and conditions of employment that could not be agreed to by the bargaining reps. Now these terms in these determinations can't be less favourable and to employees than the same or similar terms in the existing enterprise agreement. There has been a couple of cases that's come out on that, one in the last week that looks at what constitutes agreed terms. And we have prepared a case note that's in MKB if you want that. If not, give us a call and we can send that to you directly. So that will be relevant to people who are in that bargaining process, and if they are having trouble reaching agreement, this may impact you. Amalgamation rules. So these changes repeal the changes made to the Fair Work Registered Organisations Act in December 2020, covering demergers of amalgamated registered organisations. The new provision means that there is again the requirement for demerger applications from amalgamated registered organisations to be made 2 to 5 years after an amalgamation occurred. It should also be noted that the Commission is the registered organisations regulator. This will only impact amalgamated organisations that are looking to demerge, so it may not apply to you. But if it does, let us know and we can help you out. Sham contracting. Now, this is an interesting one. There are changes to the defence to sham contracting. And for those of you who don't know, sham contracting is where you misrepresent employment as an independent contractor arrangement. There are reasons people do this, such as tax benefits and having the flexibility to terminate without recourse under the Fair Work Act. The old test was that an employer didn't know and wasn't reckless with regard to a sham contracting arrangement, whereas now the test is whether the employer reasonably believed it was an independent contracting arrangement. Employers who have incorrectly classified an employee as an independent contractor may be penalised for sham contracting unless they can use the new defence. This is a harder defence to establish, unfortunately, because businesses must prove that their belief in the contractor-principal relationship was reasonable at the time of the representation. The new defence provides that an employer has not contravened the sham contracting provisions if, at the time of the representation, the employer reasonably believed the contract of employment was a contract for services. In determining whether the employer's belief was reasonable, regard will be had to the size and nature of the employer's enterprise and any other relevant matters. So what you can do here is review your current contractor agreements and assess future agreements having regard to the difference between an employer and contractor arrangement. And we can help you out with that if you need to understand what the indicia generally looks like or the factors that the Fair Work will consider when looking at what's an employer and what's contractor. So from 27th of February this year, the maximum civil penalties that can be imposed by a court for certain contraventions of the Fair Work Act will increase fivefold, from 60 penalty units to 300 penalty units for individuals and organisations. There will also be an increase in the maximum civil penalty a court can order for failing to comply with a compliance notice. If litigation is success, a court may impose orders against a person found to have done the wrong thing, and these court orders may make a person pay an amount of money as a penalty for not doing what the law says, up to $19,800 per contravention for an individual and $99,000 per contravention for companies. The court may also order the person to pay higher penalties for some serious contraventions, up to $198,000 per contravention for an individual and about $990,000 per contravention for companies. So what does this mean in real terms? Looking at the maths, currently, as of the 1st of July, a penalty unit is worth $330. This changes every year. Goes up. It was $313 last month. But basically these changes mean that a penalty for certain contraventions will go from from nearly $20,000 to nearly $100,000, which is quite significant. In addition, there will be a new threshold introduced for what constitutes a serious contravention under Section 557A of the Fair Work Act. The first criterion is the same, which is that a person knowingly contravened the provision, and for bodies corporate. This occurs when the body corporate expressly, tacitly, or impliedly authorises the contravention. So again, this is where it becomes important for people to know what they are agreeing to or what their processes and policies say and whether they comply. As of 27th of February 2024, the second criterion has changed from the person's conduct constituting the contravention was part of a systemic pattern of conduct relating to one or more other person to the person was reckless as to whether the contravention would occur. Additionally, one of the previous two things that I've just mentioned must now be satisfied to meet the threshold. The threshold for systemic pattern of conduct has been repealed, replaced with the threshold for recklessness. And the person, with regard to recklessness, where the person is aware of a substantial risk that the contravention would occur, and having regard to the circumstances known to the person, it is unjustifiable to take that risk. So these changes are significant as they will alter the likelihood of liability for the higher maximum penalties to be considered serious contraventions. Something to keep in mind there. And yeah, basically when a serious contravention happens when the court finds that the person or business knew they were contravening an obligation under workplace laws and the contravention was part of a systemic pattern of conduct affecting one or more persons. Now, these are all the areas where these increased penalties apply. And as you can see, that's quite broad. So the National Employment Standards, a modern award, an enterprise agreement, a workplace determination, a national minimum wage order, an equal remuneration wage order, method and frequency of paying wages, unlawful deductions, including cashback schemes, guarantees of annual earnings, record keeping requirements, and payslip requirements. So there's a lot there, and I mean, even just under the National Employment Standards, you've got a lot of different areas in there. Same with the awards and enterprise agreements. So if there are serious contraventions with regard to those, you might want to just make sure you understand what's happening in the business so that you can comply. So from the 1st of July, just a few weeks ago, a registered organisation such as a union is able to get an exemption certificate from the Commission to waive the 24 hours notice requirement if they reasonably suspect a member of their organisation has been or is being underpaid wages or other monetary entitlements. This only applies where the Fair Work Commission is satisfied that the advance notice would interfere with the investigation. So if they're worried you're going to destroy evidence or something like that. There will also be new powers for the Commission to impose conditions on entry permits and exemption certificates. So the impact of this is that union officials can enter your premises without notice. Further, employers will not be given the opportunity to make any submissions to the Commission prior to them approving the exemption certificate because it will be done without their notice. So what to do? I would be recommending that you audit your payroll, make sure you are paying people what they are entitled to, and respond to employee or union queries regarding pay in a timely fashion. Okay, so what to do? When I'm advising members or clients of what to do, always reminds me of this clip. We'll see if it actually works. There's a warning that there is a swear word in it. Now, just like to clarify that I don't think anyone is intentionally breaking the law, but it is the simplest way to comply. So what you actually need to do here is know the laws, understand the laws, and put policies and procedures in place to ensure compliance with those laws, and make sure that your staff are trained to know how or to know what the laws are and how to comply with them, because there will be expectations of them as well. They should also be aware of what the consequences are if they fail to comply. And that could be consequences, personal consequences in the form of liability, depending on what the breach is, or disciplinary consequences. Of course, if you ever need guidance or advice on how to comply, just call us. We'll and we can help you out. And just if anyone was wondering, no, Jim Carrey is no relation, neither is Mariah Carey. Okay, so definition of casual. Under the new laws, there will be a new definition of casual employee included in the Fair Work Act. The new definition will say that an employee is a casual only if there isn't a firm advance commitment to continuing an indefinite work, factoring the real substance, practical reality, and true nature of the employment relationship, and the employee is entitled to be paid a casual loading or specific pay rate for casuals, which is generally that 25%. Impacts, you cannot really rely on what the contract says alone anymore, and you will need to regularly assess casual arrangements. So what I would be recommending is, assess all your casual arrangements and set up regular timeframes for reviewing these arrangements. Casual conversion process has also changed, which I actually think is good for businesses. Up until 26th of August 2024, to be eligible for casual conversion, a casual employee needs to have been employed for at least 12 months, work an ongoing regular pattern of hours for at least the last 6 months, and be able to continue working this pattern of hours as a part-time or full-time employee without significant adjustment. An employer is currently obligated within 21 days of the 1-year anniversary of the employee to either offer them conversion to permanent employment or advise that they are not being offered the option to convert and on what grounds. Under the new employee choice casual conversion pathway, the onus is on the employee to request the change to their employment status after 6 months or 12 months for small businesses by notifying their employer that they believe they no longer meet the above definition of a casual employee, and if the employer accepts the notification, the employee's employment status will change to permanent employment. Should be noted that under this new pathway, the employer may still refuse the employee's request on fair and reasonable grounds, including the employer believes the employee is correctly classified as a casual employee, that there are fair and reasonable operational grounds for not accepting the notification, or there is a change of employment status, and the change in employment status would not comply with a recruitment or selection process required by a federal, state, or territory law. If the employer does not accept the notification, they must advise the employee that they do not accept it and on which grounds of those grounds I've just mentioned. Disputes about this, so if you do not accept it, then the dispute can be dealt with by the Commission now also. Definition of employer and employee. So the Fair Work Act will include a new statutory definition of employee and employer, where the real substance, practical reality, and true nature of the relationship is considered when determining whether a worker is an independent contractor or employee. Now, this saddens me greatly. Some of you may remember prior to the High Court decision in WorkPac versus Rosado in 2021 and personal contracting and JAMSEC in 2022, the mess that was created by having to assess the nature of the relationship by using a multi-factor test when determining whether a relationship is employment or contractor. Even the Fair Work Commissioners did not seem to be able to agree on a consistent approach, which made it very, very difficult. The High Court did finally make a ruling that myself and many other employment lawyers thought was a sensible determination, and this was that you go by what the contract says. If the contract says it is an independent contractor relationship, then that's what it was. It was much easier and quicker, but now the powers that be have legislated the confusion by reinstating the requirement that the substance and true nature of the relationship is to be looked at in conjunction with the agreement, thus reverting us back to the need for the messy multi-factor test. Should be noted that independent contractors who earn over a specified high income threshold may opt out of the new employee definition, whether their principal contractor has asked them to or not. Which means, so the impacts of this are basically that you cannot rely on what the contract says, and it is likely to be much more difficult to categorise with confidence a worker as a contractor, creating uncertainty for businesses and other organisations which have traditionally relied on non-employer workers. So what to do? We would be recommending that you review your current contracts and assess each new employment relationship, update recruitment and contracting policies, and train relevant staff such as managers, HR people, and those involved with hiring and drafting contracts. Consider which individuals are independent contractors or employees by recognising the differences between written contracts and how they play out in practice. Identify those highly paid independent contractors once the high income threshold is prescribed, hasn't been done yet, and consider whether it would be appropriate for those contractors to utilise the opt-out mechanism. Noting the opt-out mechanism may have limited benefit for a principal, considering that an independent contractor may retract their opt-out notice at any time anyway. Right to disconnect. Now this is an interesting one. Under the new laws, all employees will have a right to refuse to monitor, read, or respond to contact from an employer outside their working hours, unless that refusal is unreasonable. This right extends to contact from customers or clients also. Now, I just want to make sure that everyone's aware that this does not mean that you're not able to send your employee an email after hours. God knows I would be in trouble if that were the case. It just means that generally the employee may not have to read or respond or monitor those emails until they are back working, unless it is not reasonable for that person to do so. Attempts to resolve a dispute about an employee's right to disconnect must first be made at the workplace level between employer and employee. If unresolved, an application may be made by the employer or the employee to the Fair Work Commission, who may make an order to prevent the employee from continuing to unreasonably refuse to monitor or respond, or to stop the employer requiring a response to contact attempts. Any breach of such order can result in civil penalties being imposed. So if there is an order in place, again, you just need to comply with it. Now, there does appear to be some wiggle room on being able to request your employee monitor and respond to after hours contact where the request is reasonable. When determining whether an employee's refusal to be contacted is unreasonable, the following factors must be considered. The reason for contact. Why are you calling? Why couldn't it wait? Were there financial implications? Was the time of the essence? You might like to weigh up the consequences of not contacting the person. The form of contact and the level of disruption it causes the employee is also considered. So an email or text may be less disruptive than a phone call or Teams meeting. When it occurs would also play into this. So did you send the email 5 minutes after they finished work, or did you try and call them 5 minutes after they left work? Or did you call them at 11 o'clock at night? Both very different levels of disruption. The extent of the employee's compensation to perform work outside of their ordinary working hours. Are they paid overtime or penalty rates for any contact after hours? Do they get time in lieu? Has the compensation been expressly built into their salary or wage? Obviously, if there is some form of compensation or expect provision in a contract or an award, then it may be unreasonable for that employee to refuse contact. The nature of the employee's role and responsibilities will also be looked at. Is the person a senior manager? Do they deal with international clients or transactions? And are they paid handsomely to do so? Or is it a low-level employee who may not be paid well? The employee's personal circumstances, including family and caring responsibilities, should also be considered. Do they have a family? Do they need to pick up kids from school, daycare, sport after hours? And are they unable to do so if they are being contacted? Whether or not the relevant contact is required by law or for the reason of the emergency is for a general welfare matter will also be considered. So is there an emergency do they need to be contacted? Those there may be exemptions around that as well. So this may impact communication and operations within the business, and if found in breach of Commission's orders, can result in a civil penalty being imposed. Further, now that this is an entitlement to discriminate or take adverse action on an employee who can reasonably refuse to monitor, read or respond to communication, to do so will or can enliven a general protections claim. So what to do? I would be looking at your policies, your position descriptions, your job adverts, your contracts, etc. See what they say. Start building in the right to disconnect in those contracts going forward. Consider on-call, overtime or standby payments in compensation for connecting with staff after hours if you don't already have that. Ensure you know the ordinary working hours of all employees and train staff and managers on laws. We have been in consultation with the Fair Work Commission on what the model term looks like. I went to a hearing a couple of weeks ago on this, and where we advocated that we wanted the term to reflect the statutory provision and to not impose any additional obligations or requirements on employers. The draft term was released by the Fair Work Commission, it was last week or the week before, and we are glad to say that the Commission has drafted the term in that way. We are still consulting on the final term, which will be released early next month in time for the 26th of August. We are also preparing a training video on this topic, so we'll go into it in a lot more detail, or if you want, we are able to provide training to your management team and supervisors who will be having to deal with this on an ongoing basis. So if you have any need for that, let us know. Unfair contract terms. So from 26th of August, independent contractors earning below the specified contractor high income threshold, which I mentioned before, we are consulting on at the moment, but it hasn't yet been determined what that looks like, can dispute allegedly unfair contract terms in the Fair Work Commission. The Independent Contractors Act 2006 will continue to apply in respect of independent contractors paid above the new contractor high income threshold to challenge their contract terms, though that jurisdiction has rarely been used. The impact is that the Fair Work Commission is a more cost-effective, applicant-friendly jurisdiction than the court, so this will likely result in increased disputes being filed. So what to do? Review your contract terms in all your templates to ensure that the terms are fair. I guess one that is quite common is your restraints. If you have restrained an electrician for 24 months from working anywhere in Australia, obviously I think that would be deemed an unfair term. If you need assistance on what could constitute unfair terms, give us a call. All right, so what are NECA doing, or what are we doing to assist our members? So we're going through a lot of advocacy at the moment. There seems to be a full-time job of me putting in submissions and going to hearings and research interviews on various things, and that just comes from the amount of changes that are coming into place where they require consultation. So we are consulting with the relevant parties there, Fair Work Commission, departments, committees, etc. NECA or myself, I'm a member of the small business community, so we meet with other peak bodies and organisations. Fair Work commissioners are at them. The Fair Work ombudsmen come to these meetings, so we get a bit of a feel for other industries, and we sort of discuss the issues and what our industry is facing. So that's a good thing that we're doing as well. We are a member of the Australian Chamber of Commerce and Industry, where they're obviously keeping us up to date of all changes. They're advocating on our behalf, and we're advocating as well. And we're educating NECA members through things like this, through MKB. So we've just done a lot of new stuff for MKB, and we're adding more there all the time. So if you haven't been there, I think it's a little bit more user-friendly now, and there's a lot more information on there. But if there's something specific that you need, let us know. And that was that. So I will open the floor. We don't have a lot of time, admittedly, for any questions that you have. I'll try to answer them. If I can't answer them, or if we run out of time, then call member services and we can assist you directly. Julia, is that?
Hi there. I'll just pop in. So if anyone has any questions, feel free to pop them in the chat box. Can you see that chat box? If not, anyone that does have any questions, we will be sending a post wrap-up email in order for you to submit your questions. Or you feel free to contact NECA Member Services on the 1300 361 099 number.
Yeah, okay. There was a lot there, so
yeah.
Might need a bit of time to digest that. We will also be making the slides available to everyone, and I think there's a video as well, so if you need to revisit that. So okay, if there's no question.
Yeah, let's move on, Lisa.
Yeah. To move on.
So whilst we're waiting for, perfect. Okay, so I'd just like to mention, as a NECA member, you do gain unlimited phone and email access to our in-house legal team for assistance with award interpretation, wage and entitlement inquiries, debt recovery and retention of monies, contract drafting, access to agreements, letters, policies and other templates via the NECA members knowledge base. And if any members here are unsure of their login details, please feel free to reach out. I'd be happy to reset them and resend them to you. Moving on to workplace relations. So as a NECA member, you do receive unlimited support on workplace relations, including awards and legislation, agreements, employee management, including disciplinary action and termination, legal representation, immigration, industrial relations, workplace health and safety, and overall general issues. Now, the annual confidential wage review, members now have access to a free member confidential wage review. And this review is designed to ensure that your employees' wages are being paid correctly. And this includes allowances, super and hourly rates. Our NECA legal experts will review your wages thoroughly and provide you with a comprehensive report. So if anyone is interested, please feel free to reach out to myself or Lisa. Or feel free to visit the NECA website. So I'd just like to thank everyone who has attended this webinar today. If you do have any questions or would like more information about the presentation, please feel free to contact Lisa and myself or on the 1300 361 099 contact number. You can also access today's webinar on the NECA members knowledge base, which will be available to members as of tomorrow. Thank you.
Thanks, everybody.